Setting up your meeting. Okay, I think we are live. So good afternoon, everybody. I realize this is a little early. We're not usually not due to start on our normal venue until later this afternoon. This is actually going to be an official broadcast under the jurisdiction of this office, under Title 28 U.S.C. 1443, under Civil Rights Removal Statute, which clearly states any of the following civil actions or criminal prosecutions commenced in a state court may be removed by the defendant to the District Court of the United States for the district and division embracing the place wherein it is pending. That would be here in Florida. Florida was the crime scene, right? And this is against any person who is denied or cannot enforce in the courts of such state a right under any law providing for the equal civil rights of citizens of the United States or of all persons within the jurisdiction thereof. And number two, for any act under color of authority derived from any law providing for equal rights, or for refusing to do any act on the ground that it would be inconsistent with such law. Here's the cases and the citations as mandated by the federal judge. So now that we've established this office's status, standing, and lawful jurisdiction, let's dive into it. Basically what just happened, and I'm going to pull up the original establishment of this office's lawful jurisdiction pursuant to this document. This office was created by the consent of Congress. It is what it is in this case. So, the preface for the creation of this office is going to be as follows. This following report is presented for review in good faith as a friend of the court under license number 443079 as a fiduciary practitioner consisting of 9,301 words on 39 pages, not including dicta and appendix sources. My license holds and is subject to the high standards consistent with other fiduciary practices of care, sense of fair play, and equal protections under the law. My work is presented to this court in efforts to assist the case presentations in working with the plaintiffs in these matters toward protecting the integrity of these proceedings. The court, that means Lady Justice, and these plaintiffs in congruence, a task not undertaken lightly, as the very course of multiple lives will be forever altered. Therefore, the utmost care must remain the standards of practice, right? This is those high fiduciary standards we talk about to ensure the continuation and protection of the Constitution of the United States be interpreted as the 56 men who constructed it intended, basically. So what may seem so rudimentary to so many when in consideration of basic equal protections and basic due process, that would be that basic Magna Carta due process, as related to this practice, are luxuries that has never been afforded. The fact it has become arrogant and hostile is a side effect of this type of exile, meaning the bar and its practitioners. It is for this reason my personal choice of profession was outside of this area of service for years. That was until I received a knock on my door, which forever changed the course of my life and forced me into action for no other purpose than self-preservation in my own case. Like so many before me, I had, for the longest time, given up and decided not to care. I then remembered this quote from the Declaration of Independence, which led to my work. But when a long train of abuses and usurpations pursuing invariably the same object, evinces a design to reduce them under absolute despotism. It is their right, it is their duty, in my case, the fiduciary duty, to throw off such government and provide new guards for their future security. Well, that is the commencement of loss prevention, right there. So basically what happened when these foreign actors violated the Foreign Emoluments Clause, came in here and thought they were going to take over the place, not happening. We have law against that. It's the Foreign Emoluments Clause in the original 13th Amendment, which I further outline in this report. This is the reason that this conduct has oversight, and my office does have oversight under the aforementioned jurisdiction. Therefore, in so much as lawful notifications are concerned, this is the notice to agent, notice to principal. Under Bullock, where fraud upon the court is directed to the judicial machinery of the court itself, basically is a short version. Here's the letter of the law, Article 4, Section 4. We're guaranteed a republic. I don't care if you bar members like that or not. I could care less. So what just happened? What just happened here was violations under the Hobbs Act, and I'm going to specifically define what they are. Under Hobbs Act, extortion and robbery, which is Title 18 of the U.S. Code, subsection 1951. Robbery, extortion by force, violence, or fear. Unlawfully taking by force, violence, or fear. Fear of injury, property. Extortion under color of official right. And, of course, affecting interstate commerce. So this is the body of law that was just violated this morning. Right? This process was lawfully served, and I'm going to show you when here in just a second. Right? Remember that object being pursued in the design and mentioned in the fiduciary practitioner's report? Does that look familiar? I certainly hope so, because this is that Sharia law that I talk about. Right? And in so much as the letter of the Constitution in the Republic is concerned, even its introduction is a violation of the 9th principle of group decision-making. Period, end of discussion, which is why the Supreme Courts will have declared its enactment void, which I'm going to clarify here very shortly. Now, whether you prefer remonstrance or remonstrance or however you pronounce it, at this point, I really don't care. This notice of process was received, right, by the state prosecutor on this day by my client. So this was received. This was processed. My client is also an officer of this court, makes her protections under this company valid, like it or not. So any intimidation of either myself or my client falls under violations under the Hobbs Act. And I have jurisdiction for that. I have power for that. Just so everybody knows. So under the lawful process, right, under the rules of the Republic, page 17, section 7, numbers 1 and 3 are as follows. Constitutional provisions stand on a higher plane than statutes and are mandatory. If Congress or state legislature violates a constitutional requirement, the courts will declare its enactment void. Hence the reason this is above Kentucky's pay grade. I've already removed this case under federal civil rights removal statute, as I clarified. Page 25, section 16, where there is more than a mere technical violation of the rules of procedure, which I just provided notice of, the violation may invalidate the act, and an act will be invalidated where there is fraud or bad faith. It is reasonable to assert failure of consideration. This is actually not part of the section, but in this particular case, it is reasonable to assert failure of consideration as an affirmative defense in this case. And I'm going to clarify that as we go through here. Of course, my client signed it, right? And it is, of course, stamped. Proper notice of process has been followed. Due process and notice thereof have been followed, right? So this is the notice of filing. to Attorney General. He stamped it. It is what it is, right? This was provided to the court. Notice to agent. Here it is. For the Masons motion 39 in the 116th Congress for the United States of America in the matter of weaponized family courts, that would be this report right here. Okay? So, in so much as, where the heck was I? There I am. Okay. This is the reason for this resolution and motion to expunge. Okay? So, as this case involves multiple states' violations of the Commerce Clause of the United States Constitution, remember, Florida was the original crime scene, hence the reason this company has jurisdiction. Every bit of this is verifiable, hence the reason the Attorney General stamped it. This motion to expunge comes before the body in due course of doing business as the subject of this matter is certainly frivolous in nature due to Sharia law is not recognized in this republic. It is recognized as fraud. Those emoluments do not exist here. Period. Swift expungement of this matter is also clearly justified and appropriate. It also will open doors for potential failure or for potential future business relations between this company and your state in the future as an ally in fighting future emoluments violations under the Foreign Emoluments Clause. Right? You need a watchdog up there. I volunteer. My client volunteers as well. So there's your motion to expunge, right? And resolution. That's how we do business in a republic. It is what it is. So notice process to the Kentucky State Legislature. Basically the same document, right? And this is the remonstrance, however you prefer it. My client and, acting as an agent of this office versus Kentucky et al., right? I am the CEO of this company, and she is my corporate officer. She's an officer in training, teaching her how to do this. So, excuse me, the Office of Loss Prevention, there's my corporate identification, my fiduciary numbers, this is all verifiable, and of course my notary credentials is a lawfully created office under the state of Florida. It is what it is. In other words, to know a thing and to be bound to know it are regarded in law as equivalent. It's a maxim of law, period. Know it, learn it, understand it, live it, breathe it. So, in so much as the preface of this case, following grievances expressed within the rights and privileges of this plaintiff in her personal capacity, citing emoluments violations under United States versus Throckmorton from 1878 in her personal capacity and Hale versus Hinkle in a professional capacity or official capacity, and all applicable federal law, Kentucky, Georgia, South Carolina, and Florida state law as needed. Kentucky, Georgia, South Carolina, and Florida state statutes of limitations as needed, and sections outlined throughout this document. Predicating this grievance pursuant to the following due process and judicial civil rules of procedure, because the only evidentiary standards I'm aware of are preponderance of the evidence under civil law and beyond reasonable doubt under federal law. Well, we're here to provide reasonable doubt. So if we can provide reasonable doubt, there is no preponderance of evidence. End of discussion. Under Federal Rule of Civil Procedure 12H1B2, we are wishing to preserve certain defenses as listed above. Failure of consideration, contributory negligence, release of my client, my corporate officer, and all of her property, injury by fellow servant, and of course, statute of frauds. So those are the defenses we will be proceeding under. First Amendment, Congress shall make no law respecting an establishment of religion. That seems pretty clear to me. Don't need any title, don't need any code, don't need any statute, rule, or regulation for that. That seems pretty clear, right? No, nothing vague there, is there? Right? So, as I just outlined, here's the petition, the section under Jefferson's, and resolution, right, under Jefferson's. There it is. So, there's a Hobbs Act, the property as defined. The term property includes money and other tangible and intangible things of value. That would be my client's rights, that basic Magna Carta due process, which was just denied and usurped. Extortion under extortion under color of official right. Well, that you don't have the power to do. Nobody has the power to do that. Talk about the list of stuff not to do. Well, excuse me. The government alleges that the name of the actors in this case to be disclosed in oversight committed extortion under the color of official right on this date. Today is 6/3/2020. A public official or employee commits extortion under color of official right if he or she uses the power and authority of his or her office in order to obtain money, property, or something of value from another to which neither that public employee, official, or employee, nor the government office has an official right. Extortion under the color of official right means that a public official induced, obtained, accepted, or agreed to accept a payment to which he or she was not entitled, knowing that the payment was made in return for taking, withholding, or influencing official acts. This is exactly what happened. I bared witness to it. My client was threatened. I was threatened. I don't respond well to threats of domestic terrorism. Not happening, period. So the section further goes on to say, well, that's affecting interstate commerce, so we won't mess with it. So, in so much as the state process is concerned, because the state actually stands on a higher plane, right? Remember, the Constitution is supreme law and minimum due process. Well, we want the maximum protections for my client and her property, specifically her children. Page 17, section 7, we went through that. Page 25, section 16, we went through that. Page 29, section 35, number 3, the common law of parliamentary procedure is founded upon well-established reasonable use. So it does not rest upon mere custom, but upon reasonable and equitable custom. Oh, remember those maxims from the short list? Here's one of them. What is not reasonable is not law. It's in the context of the Mason's Manual. So don't tell me legal maxims are not applicable in law. They are. May be said with reference to the common law of order in deliberative bodies, as well as the common law of the land. As we said, Title IV violates this section, page 38, section 43, number 9. There must be no fraud, trickery, or deception resulting in injury. As in other situations, a person is liable for damage or injury intentionally or negligently caused to another. And failure of consideration is gross negligence, period. Page 62, section 73, number 1. The people are vested with sovereign authority. My client was there to exercise her sovereign authority and was run over, expressed by their representatives serving in a legislature. Thus, legislative power is absolute and unlimited, except as restrained by constitutions. In so much as lawfully created agency practice, that would be What I cannot do in my person, I cannot do through the agency of another. Period. In other words, you don't have to tell me that. Fundamentally, principally, I know that. Was on the test, by the way, which I passed. Page 294, section 443. Number 3, a legislative body can ratify only such actions of its officers, committees, or delegates as it had the right to authorize in advance. It cannot ratify or make valid anything done in violation of the Constitution. We just showed where it was. First Amendment. Can't make any law respecting the establishment of a religion. Can't do it. Nice try. Too bad, so sad. No motion or measure is in order that conflicts with the Constitution. I'm sorry, page 353, section 517, number 1. Right out of the box here, people. No motion or measure is in order that conflicts with the Constitution of a state or the United States Constitution or with treaties of the United States, and if such a motion or measure be adopted, even by unanimous vote, it is null and void. Basically, void ab initio. If it were any more self-evident than it is today's political spectrum as to which side of the political aisle has been engaged in hate politics, you need only refer back to some of the declared conduct of tyrants, clearly spelled out in the Declaration of Independence as follows. He has refused his assent to laws the most wholesome and necessary for public good. Star chambers are inconsistent, repugnant to our republic. Hence, what just transpired as a result of a star chamber clearly falls under this conduct. He has refused to pass other laws for the accommodation of large districts of people unless those people would relinquish the right of representation in the legislature. A right inestimable to them, formidable only to tyrants. He has called together legislative bodies at places unusual, uncomfortable, and distant from the depository of their public records for the sole purpose of fatiguing them into compliance with his measures. Remember, we've discussed it on our show. That would be those code commissions that in Peterson versus Peterson, the High Court ruled they have no legislative authority. Period. Can't go in and edit the law. Any law. I don't care what it is. That's claiming exercising a power you don't have from a pillar of law that doesn't exist here. This is why these are attacks at law. End of discussion. He has dissolved representative houses repeatedly for opposing with manly firmness his invasions on the rights of the people. This is my 6-pillar manly firmness foot talking here. So, hence one of my favorite acts from my legislation that we just commenced impeachment on. He has erected a multitude of new offices, sent hither swarms of officers to harass our people and eat out their substance. Well, if that one weren't any more applicable in this case, I cannot think of another place or another case where it is any more applicable than this case. Just saying. For imposing taxes on us without our consent by way of those star chambers, that Title 4D, right? For depriving us in many cases. Why is that a tax? Let me clarify that. Because as I audited Title IV and found out they were stealing 80% of the money in my own case, which I had standing to audit. At that moment, that theft constituted a loss of any status, any standing, or any jurisdiction by that office. Hence the resolution to resolve and dissolve that office. Period. I just think it's ironic that a couple of days ago, as I understand it, in the state of Texas, the child support office was burnt down by the people. Boy, if that isn't any indicator that the people ain't having Sharia law, I don't know what is. I think the people have spoken, right? Another one of those maxims of law from the short list. The voice of the people is the voice of God. Well, when they're burning your buildings down, it's one of the 7 danger signs. You better quit doing what you're doing, right? So, for depriving us, in many cases, the benefits of trial by jury. That's exactly what just happened here. It is what it is.
Yeah.
In every stage of these oppressions, we have petitioned for redress in the most humble terms. Our repeated petitions have been answered only by repeated injury. Remember, we have been spurned from the throne with contempt, right? Remember that from the Sir Patrick Henry's famous speech, give me liberty or give me death speech?
Yeah.
Right? Remember that? I'm just saying, it's a little bit of history there.
Yeah.
So the only requirement for practice in law is knowledge of law and a knowledge of history. I think even bar members are taught Sir Patrick Henry's speech. So, just saying. So, prudence speaking from the Declaration again, prudence indeed will dictate that governments long established should not be changed for light and transient causes. And accordingly, all experience hath shewn that mankind are more disposed to suffer while evils are sufferable than to right themselves by abolishing the forms to which they are accustomed. My favorite line from the Declaration, we now know what the object is and we know what the design is. So I said, this is above Kentucky's pay grade, period. That crap, shenanigans, kangaroo court, my client and I are not marsupials. I got some news for you. That would be an odious claim. You know, that's this section right here, these kangaroo courts. That's exactly what just went down here. Another kangaroo court, right? So, yeah, not happening. This is why, under Florida law, the people again voted for a victim's rights amendment. Well, under Sharia law, Lady Justice is the victim, and the victim has rights. So, because the crime scene in this particular case originally was here in Florida, Lady Justice being the victim, as my client was denied that basic due process, Lady Justice and my client have been the victims ever since. They have rights. I'm here to assert those rights. So, the above act of Congress, Title IV, having the effect, remember the cause of the thing causing, which is the cause of the effect. So, Title IV et al. Having the effect of fundamentally altering our form of government established in 96, forfeited any further right to contract on behalf of and or with its people and businesses as written in Article 4, Section 4 of the Constitution of the United States of America, being properly ratified, citing certain leeways extended in good faith since the Reconstruction Act of 1871. As the courts have long upheld dispensing issues involving fraud and bad faith throughout the history of this nation, I feel certain this case would not withstand the necessary legal scrutiny of a long litigation process under the current circumstances. Statutes, codes, rules, and regulations are not law. See Peterson versus Peterson, appendixed in this document, where that Supreme Court judge actually outlined it for you. It is with a certain sense of pride and satisfaction I got to see the end of these violations of Article 1, Section 9, Clause 8, also known as the Foreign Emoluments Clause, through the efforts of a job that my father did before he died in 2006. This, of course, is Neely's case. He and Christopher Edward Hallett have dedicated a substantial portion of their life to defending known as loss prevention. The fact it is founded on such fundamental legal maxims as fide et fiducia, basically in faith and trust, and the malicious designs of men must be thwarted. In closing, I wish to inform you of the following fact. Anyone who has been passing around misinformation as to my death, meaning my client, in all caps, the dog Latin, I regret to inform whomsoever made this claim, I got better. And I'm still known as Neely Blanchard, alive and kicking. Sorry to be the bearer of bad news, but we've been had. By who? That would be these useful bar idiots while we were at work all day long. So their version of reconstruction, or their version of infrastructure projects and our version of infrastructure projects, no. So that would be that monopoly leveraging. We were just, matter of fact, Attorney General Barr just spoke about that over social media, over a social media executive order the president just signed, basically ordering that activity is repugnant to the law. Also clarified in my judicial report. Let's see here. That was researched by this office. Here we go. Legal monopoly. This is all from page 1160 of Black's Law Dictionary, 10th edition. Legal monopoly from the 18th century. Monopolies from the 16th century, right? That branding, right? We've discussed that. My client has been branded. I thought we quit doing that in the late 16th century. So we now have these bilateral monopolies, these foreign emoluments, creating these bilateral foreign monopolies, hence the foreign emoluments clause. Exercising this monopoly leveraging, right? Monopoly through their monopoly powers they don't have. Period. We've discussed this, such as unauthorized practice of law. That's laying claim and exercising a power you don't have. Period. That's been tested and defeated so many times in multiple federal courts. Don't even try it. Talk about repugnant. So, there it is. Congress shall make no law respecting an establishment of religion. The First Amendment. It's a reason that this office was created. I knew what you were up to while I was at work all day long. So, we're going to talk about the common law. That would be God's law, hence the citation of the Lord's Prayer. So, and of course, there it is. The voice of the people is the voice of God. Hence, proper service of process. It's already happened. The fact that they don't want to accept that they're caught and they're done, well, that's unfortunate for them. So in so much as the notice of appearance is concerned, right? This is in Congress. You were served it. Here's your notice of appearance. Christopher E. Hallet, doing business as E-Clause LLC, is hereby filing this notice of appearance to my status change, fiduciary expert, friend of the court, per the following circumstances and establishment of practice, to retask my fiduciary license to serve the people of the United States of America as loss prevention co-counsel for the government of the United States of America and plaintiff in this matter. On March 13, 2017, POTUS, President of the United States, issued a lawful executive order, 13781, in which President Trump asked for help from the citizenry. That would be those with those lawfully created emoluments. I know that. I got one hanging on my wall. To assist in the restructuring of the executive branch. Again, a task not undertaken lightly. Citing the Ketam provision, there it is. I am following said executive order in a continued effort to expose these continued assaults upon the court by frauds upon the court through malfeasance of office and prosecutorial misconducts resulting in multiple emoluments violations through Sharia law. This office does business hunting for the following red flags in both public and private sector corporations. That is a public sector corporation. Audit forthcoming. Pursuant to Article 1, Section 9, Clause 8, the Foreign Emoluments Clause. So, what is an emolument? In order to, basically, under this legal maxim, in order to rightly comprehend a thing, it is necessary first to inquire into the names, for a right knowledge of things depends on their names. So the definition, as recognized in a republic, 3 pillars here: advantage, profit, and gain. Any advantage, profit, or gain received as a result of one's employment or holding of office. That would be those stipends that Bill Barr talked about during his confirmation process. We already know about falsehood. The law punishes falsehood. This is the reason everything that's transpired is literally a defamation, libel. Further pursuance of this action against my client, any in this office, is libelous. Know it, understand it. Under my fiduciary licensing, my reciprocity agreement with the people, as I clearly outlined, there's its definition as a corporate officer. I know my job. Been doing it for 30 years. I'm really good at it. So, again, what is unsuitable or contrary to reason is not allowed in law. I think we just cited that into this context of the Mason's Manual, didn't we? Mm-hmm. So, notice of appearance covered. So, what are we going to disclose today? Well, remember, full disclosure is a requirement under lawful agency practice, right? We've discussed this. Discovery in the criminal or civil process as seen by Lady Justice. Full disclosure in the private sector. Those things are equal, right? Lady Justice has the right to discover, right of discovery here, as since she is the victim, as is my client. Again, received. Period. Somebody want to explain to me and my client why the court was denied this exculpatory evidence reciprocity agreement between the quote unquote plaintiff in Kentucky and my client. Somebody want to clarify that for me, because this is going to be brought before oversight. So under the required records doctrine, be prepared to bring your case and all of your files to oversight, because you're going to answer for this, right? It is what it is. And there it is, signed and notarized, right? There is another document, an authorization. It looks a lot like an authorization to me since it's titled as such, and it is signed by your plaintiff up there. So this would be exculpatory on behalf of my client, I would certainly imagine. So denial of this evidence being brought into today's process is an emoluments violation under Brady. And I'm going to petition for a contempt sanction against any actors who are so involved in in this process. Period. You're done. You're going to remove you from office. You're going to be impeached. I'm sure you know what impeachment is. And of course, we'll go into where everybody was served. Through email, were served. Let's see, Office of Attorney General memorandum. This is from, General Barr, I think, put this out, isn't it?
Yeah, it is. It was served on them a while back ago.
Right.
And they act like they can't find it. Yeah.
So again, this came from the Attorney General of the United States. You were served, you now have been served notice of process, not just by this office, but you were served also on November 16th of 2017 wait a minute, that could be Jeff Sessions. I think this is Jeff Sessions.
Yeah.
But this also holds prohibition on improper guidance documents. These Title IV Sharia law courts? No. That was shut down in November of 2017. What are you doing? So we're going to motion to suspend the rules of Title IV, right? This, again, I just showed this. This was also served by my client. Proper service process. This office has jurisdiction, right? The defendant by plea or exception becomes plaintiff. This maxim of law right here. What's the plea or exception? Emoluments violations under Brady. Period. Know it, accept it, understand it. Justice and fraud are basically incompatible. That's pretty much what that one says. I'll go down the short list if anybody wishes me to. So, without going through the entire petition again, this is pretty much exactly what just happened. So, this is going to conclude today's official meeting, unless, of course, my client wishes to provide a statement. Now, knowing and understanding that her First Amendment right was just violated because they attempted to gag her. No, that would violate your free speech.
Right.
So, again, right. As far as I'm concerned, as far as your corporate counsel is concerned, I'm telling you that violated your First Amendment right. So, right. And I'm providing notice of process as to that violation and where and why it's above their pay grade.
Right.
I've already handled this case.
Right. Well, they know they're depriving my liberty interests. They just, Well,
and again, it's Islam. Welcome to Islamic Nation.
Right.
Well, in so much as the modeling is concerned, let me go through the model that just happened. Right. You guys have seen this. You guys have seen this model. Right. In proper agency practice, that quid pro quo, the what for what, and the reciprocity, that would be an equal return, right? Reciprocity agreement. Well, these government monopoly markets with little to no reciprocity, all managed by foreign emoluments, bar members, working from pillars of law, violating Article 1, Section 9, Clause 8 of the Constitution's Foreign Emoluments Clause. Period. This is why the high courts, correctly ruled as they did, invalidating Title IV et al. And Obamacare, basically et al., in context mandating full repeal. Hence the reason the Foreign Agent Registration Act was just expired. Happy trails. Don't let that Admiralty jurisdiction anchor hit you in the ass on the way out the door. Right. So.
And star chambers are unlawful.
Oh, yeah. Yeah, those are definitely the ultimate in repugnance. Again, what I cannot do in my person, I cannot do through the agency of another, which is why this office is holding a public disclosure. See the difference here?
Yeah.
Between what they're doing and what we're doing?
Yeah.
So, again, if I'm going to train you, I'm going to train you correctly.
Right.
Not incorrectly as they have been trained.
Right.
So, because these things have already happened, right? It is what it is. And so, in so much as discovery, okay, well, let's talk about the Hobbs Act. There it is again. And let's go. So as far as the slideshow, inevitable discovery. Yeah, what is inevitable discovery? This is an exception even in criminal law, right? Even if there was any kind of misconduct, as these are in plain view, there's the emoluments of my office. What does that mean? That means I am amenable to the people. It is what it is. So as a lawfully created emolument, amenable to the people, I'm doing that job. I don't care who likes it. President asked for my help, and I'm going to tell you right now, going back to the Minutemen, Annals of America, Volume 2. Look it up, verify it, know it, live it, breathe it, understand it. President issues a lawful executive order asking for your help. I'm duty bound, fiduciary duty bound to respond to that.
And we have a duty.
Well,
period.
again,
You know,
I know the law. I've forgotten more about the law and the republic than these people will ever know. It's kind of the nature of practicing the republic for 30 years.
Right.
In so much as due course is concerned. So remember, we've talked about this. Your dad's position and my position in our companies as corporate officers was literally the corporate parliamentarian. We're the backbone of the company, right? He'd get a phone call. He had to quit whatever he was doing to respond.
Yep.
It is what it is. It's the nature of the job.
Yep.
This is no different. This is no different.
I know.
So on that, I'm going to go ahead and end this live stream right now. So anybody who is paying attention to this, who is in official office of emolument with reference violating my client's rights, or if you think you're going to intend to violate me, I'm going to hold you in contempt, and I have power to do that. So in so much as one last final thought here, one of the reasons why this this particular case was removed by this office, remember, I did an audit of this case. And what did I find? Right? I decoded this case. We talked about this one night on the show. And because this right here, Kentucky, this is what they're currently trying to pull, 4243, right?
Yeah.
From 2014. Wait a minute. What year is this? Okay. Yeah. There was never a hearing on this, right?
There was never a hearing.
You never
went to court.
Okay. So you were denied due process.
Yes.
Period. So how are they proceeding under something that you were summarily denied basic Magna Carta due process? Right. So in the decoding, remember, I clarified this. I have found just in that system, okay, there are two files, and both files do not contain the same information. That is the selective inclusion of and selective exclusion of relevant evidence and testimony, which prejudiced the court against my client. Emoluments violations under Brady. Period. Dating back to 2014. They never had any status. They never had any standing, and they never had any jurisdiction, notwithstanding foreign emoluments notwithstanding, right? But any jurisdiction they may have had. When they created these shenanigans, right? This is a file and a sub-file, right? They say, oh no, it's in the system. Yeah, it's in the system, but as you can see, the file numbers are different. So if you're going to search for something in either one of these, if you don't put the 3 zeros in, you're not going to get the whole picture. Right? That would be that information in due process that's required, that Brady information, right? That fundamentally alters the proceeding. Well, it is what it is. So there is your visual citation of emoluments violations under Brady with respect to this case dating back to 2014. Attempted to provide this information this morning and was threatened for that service. So again, I don't respond well to threats under domestic terrorism. We have law against that. That's domestic violence under Article 4, Section 4. So know it, understand it, deal with it. This office does have limited judicial power under that jurisdiction. I removed this case because of those violations in the audit conducted by me. Right? Okay.
I was threatened too.
Yep. So
again.
Anyway, on that note, for everybody who is getting ready to tune in to Kirk's Law Corner later on this evening, we will see you tonight for Wednesday Night Live.
Bye.